One of the examples, one of the areas that we do a lot of different policy advocacy, but as it relates to our early childhood work, one coalition that we're a part of is Early Learning PA, and we're active leaders within the Thriving PA group, which we're advocating within there. We're part of the statewide initiative that's advocating for improvements and increased funding for Part C early intervention. So that's early intervention for kids who are birth to 3. And that work really just as an example, so they can get a sense of some of the policy advocacy that we do. That work really came out of a year-long stakeholder survey that was done, or there were focus groups, lots of different ways. Maybe some of you who are involved in Part C early intervention were contributed to this, but developed a stakeholder report that issued findings about where there are gaps in our current system for providing Part C early intervention throughout the Commonwealth, and also, in terms of where systems need to be coordinating and collaborating more, including through the Medicaid system, behavioral health system, because all of these systems are designed to really support our youngest learners, and we need to be advocating to make sure that both there's sufficient resources for those systems to be functioning, but also if there are some gaps in terms of outreach, referral, enrollment, evaluation, that those are being addressed through policy changes. So we're working with a statewide coalition on that. And if you're interested in learning more, because this is really just a portion of it, feel free to visit the thrivingpa.org website. We also are involved on social media, and also you can, if you're interested in getting onto our news, getting updates about the work that's happening, you can email info@papartnerships.org to get your name added to that. And but the Thriving PA website has a lot of different fact sheets that relate to Part C early intervention. Okay, so the agenda for today is, now that you know a little bit about the work that the Education Law Center is doing, we're going to talk about the importance of early childhood education. Hopefully, most of you already know that maybe this will be a repeat, but I think we always like to begin by making sure that we have a common understanding of how foundational early childhood education is for later success, both in the school age programming, but then even beyond that. We're going to talk about sort of what some of the both the research about who's being excluded from early childhood education, but then also some of the practices that are fueling it. Then we're going to talk about early intervention, early childhood rights. So for both 0 to 5. So that's going to include Part C, like I just said, but also Part B of early intervention, which is for kids who are 3 to 5. Then we're going to talk about other protections for students under both for those students who are experiencing homelessness under McKinney-Vento, and those students who are in foster care. And then we'll give you some contact information for us and other resources that you can find for us. You want to go ahead? Great.
Yeah, so I will take it over for this section. Like I said, my name is Rose, and I'm a legal fellow at ELC, and I work specifically in early childhood education. And the thing that we know most about early childhood education, and that all of you know, is that it's really, really important, and research really supports this. So, children's experiences in their first 5 years are critical to brain development. I have this icon here, and I have that because about 90% of a child's brain develops before age 5. So, the quality of experiences that they're having up to that point literally shape the structure of their brain, which they will have for the rest of their lives. And I think that's a good way of summing up the importance of early childhood education. Beyond that, research is really clear that access to high quality early education, so not necessarily any program, but high quality early childhood education, is associated with lifelong positive outcomes, including increased graduation and employment rates, increased financial independence, longer lifespans, and academic, behavioral, and social benefits. And also, while we see that all children benefit from high quality early childhood education, research also shows that when underserved children are given access to high quality programs, they make the most significant learning gains. And as a note, we'll be talking about special populations today, where particular protections apply and where they don't. But all preschools in Pennsylvania are required by the Office of Child Development and Learning and Early Learning, OCDEL, to work to prevent, reduce, and ultimately eliminate suspension and expulsion. So suspension and expulsion is not something that should be happening to any preschooler in Pennsylvania. And when we talk about preschools, we're talking about preschools, how many people think of them, but we're also talking about daycares, pre-K counts programs, childcare works, childcare voucher programs, Head Start, early intervention, IU placements, school district programs, private programs, really anywhere that a child might be going for early childhood education. Although, as we will discuss, different laws apply to different funding sources. And hand in hand with the really important benefits of accessing early childhood education are the negative consequences of being excluded from those opportunities. So we find that very often children are excluded from early childhood education settings. What we do find, in contrast to school age programs, is that the words suspend or expel are sometimes used, but very rarely. More often, children are excluded and told that they are not a good fit or a safety risk. Children are told they cannot come to school if they do not have an aide, regardless of whether or not an aide is in their IEP. We see children who are unenrolled or placed on shortened schedules, so they may only be allowed to come to preschool until noon. We see children who are sent home early every single day, or parents are called halfway through the day to pick up the children based on their disability-related behaviors. We see programs where children's service providers are not allowed to come into the building to deliver services, where children are allowed to come to school but isolated within the school or placed outside of their classroom. And then programs where children are denied enrollment based on disabilities, housing status, or something else. All of these and more are instances of early childhood education exclusion. And like we will talk about in a moment, there are lots of implications for that. So first off, beyond the fact that this should not be happening, suspensions and expulsions do not teach appropriate behavior. They do not allow children to access those really important benefits that we talked about, and they do not make programs safer. We also know that this is happening really often, especially when viewed against a school age lens. So preschoolers are excluded at a rate more than 3 times that of K through 12 students. So this is happening really, really often. In 2016, about 175,000 preschoolers were suspended and about 17,000 were expelled from a program. And another note here is that this is not an area that good data is available on. It is something that there is a need for more data within. And another reason that this is important is because funding for public programs is so limited. So when a child is expelled from the program and their spot is given away, it's not as easy as just going to a new preschool tomorrow, because there may not be a spot available at a preschool tomorrow. So in Pennsylvania, more than 145,000 children are eligible for publicly funded preschool, but of these, only about 66,000 children will actually have access to such a program. And also, like Margie mentioned earlier, we have a lot of research supporting the school to prison pipeline, but research also shows that this is potentially better viewed as a preschool to prison pipeline. So when children are excluded from preschool, their risk of future exclusion and later justice system involvement increases significantly. And it really does start as young as preschool. We see that suspensions and expulsions are often associated with negative educational and life outcomes, as opposed to the really positive ones we talked about. And another common situation we see is that when children are expelled from preschool or are suspended every single day, it often places a parent's job into jeopardy, and they cannot necessarily keep that job when they lose their childcare, especially when that's based on disability-related behaviors that a child may not be receiving services for. If that job is lost, housing may be jeopardized as well as other elements of stability, which is a really traumatizing and stressful experience for both families and for the children. So sometimes we see children who don't want to go back to preschool or don't want to start kindergarten because of how difficult their experiences have been so far. This preschool exclusion is something that teaches children that they don't belong in educational environments and teaches them that school isn't a place that they belong before they even set foot in kindergarten. And as with many other areas in education, this is an area that is rife with disparities. So, due to discriminatory school rules and discriminatory application of discipline and those rules, there are really wide disparities in who is excluded from preschool. There is research showing that 250 children are excluded across the nation every day, and 125 of them will be Black boys. Black children represent 18% of public preschool enrollment, but 48% of the population receiving multiple suspensions. Black preschoolers are 3.6 times more likely to be suspended than white preschoolers, despite having the exact same behaviors as their peers. Boys are 3 times as likely as girls, and children with disabilities and emotional challenges are 14.5 times as likely to be suspended or expelled as typically developing peers. And like mentioned, something we focus on at ELC is intersectionality, which means that children who might identify with one or more of these markers are especially at risk. And another thing that can play into this is adverse childhood experiences, or ACEs. So preschool children who have experienced ACEs are as many as 10 times more likely than their peers to be suspended or expelled. And these ACEs might include poverty, inadequate housing, homelessness, abuse, neglect, involvement with many of the systems that we and you work within. So this is particularly important for your populations. And just a note on that within Pennsylvania and on child homelessness and poverty. In the school year 2022 to 2023, about 47,000 children were identified as experiencing homelessness in Pennsylvania. Of these, 14% were children aged 0 to 5 and not yet in kindergarten. 26% of these children are identified as having a disability, and in 52 counties, this number rose in the years coming. Additionally, about 15.2% of children in Pennsylvania live below the poverty threshold, and these children are, again, that are especially at risk to experience preschool suspension and expulsion and for their needs to not be met. In Pennsylvania specifically, although also across the nation, there are some really clear systemic barriers that have fueled preschool suspension and expulsion, as well as inadequate services. So, due to individual racial bias and structural and systemic racism, Black and Brown children are disproportionately subject to preschool suspension and expulsion, which is in line with national and in-state statistics that we shared. But there's also, particularly in Philadelphia, a lack of equal access to EI services and health services to address developmental behavioral needs for Black and Brown children, who are also especially likely to be overlooked for these critical interventions. We can see really clear cross-system breakdowns in communication and collaboration, especially when working between systems or potentially aging from Part C to Part B or to kindergarten or moving across counties. We see increasing numbers of children experiencing barriers such as homelessness and poverty, a lack of training and supporting children with challenging behaviors, and then staff shortages and a lack of support for those teachers in supporting these children as well. So, what can ELC do? This is an area that we are taking on many more cases on as they come to us. Something we can do and have been doing is advocating against exclusions, these suspensions and expulsions, by reaching out to preschools or submitting legal complaints. We can also provide consultation on a limited basis or potentially representation to families experiencing issues with preschool or preschool early intervention. We can advocate for more appropriate supports for the child if potentially the wrong services were being delivered, services were not being delivered at all, or something like that has contributed to this school exclusion to ensure that the family can access both the program and the EI services. We can connect families with resources, including potentially how to find a new preschool spot because it can be so challenging to work within the funding systems, especially if a child has been expelled in the past. And we can also secure compensatory education settlements for children who have been deprived of EI rights and help them find resources to make sure they can access services in the future. And then something else we can do at ELC is advocate for systemic change. So while we take on these cases one by one as they come, we're also able to see some of the through lines and work on those higher level issues.
Okay, I'm going to take over for here for a little while. And we're going to talk about early intervention rights. So early intervention, as I said previously, it's actually um, two free programs that we have. So it spans the ages of birth to 5 or 6, depending on whether the child goes to kindergarten or enters school at the age of beginners. And EI is designed for children who have developmental delays or disabilities. And it is a free program that provides services that are included in an individualized plan, either an individualized family service plan or an IFSP, or an individualized education program, an IEP. And those are annual plans. The early intervention IEP looks very much the same and includes many of the same components that a school age IEP would have. And so I usually like to say even though they're both called early intervention, part B, which is for kids who are 3 to 5, is more similar to a school age program than it actually is to part C. Part C really is a model that is, as the name suggests, individualized family services plan. It is really about giving services to children, but teaching parents have families how to be, teachers for their children who, because of all the learning that will occur in the family. So, to as I said, the idea of early intervention, just like the name suggests, we want to intervene early because we know, as you know, the research that Rose talked about, that's for all learners, that really also includes very much so children who are experiencing developmental delays or disabilities that correlate with developmental delays. This is a time of rapid growth. And so this program is designed to intervene to address that where where children are maybe falling behind in comparison to their peers, so that they're ready to enter the school age program. And it's created under the Individuals with Disabilities Education Act, the IDEA. So, as I said, there's Part C, 0 to 3 of the IDEA, and there's Part B of the IDEA. And Part B is 3 to school age, and Part C is infant and toddler. So we call it in Pennsylvania, we also will call them preschool early intervention or infant and toddler early intervention. So typically, I know I saw intermediate unit staff who've signed into the chat. So early intervention is administered by intermediate units, or in Philadelphia County, where we are, by Elwyn. That's Part B. Part C is typically the county mental health departments or in those county offices. So each system is county-based, and we do see that there are some differences in how the programs are administered within the umbrella of everything is supposed to be consistent with the federal and state law, but there are some differences in terms of, assessment tools that may be used in one county versus the next. But it is created by a federal law, and so there are rights for families and students about how they can both be involved in creating those plans, providing those services, and then options for if they disagree with what's being provided. And in Pennsylvania, it's free regardless of income. And there are some states, the federal law allows Part C, so the infant and toddler program, states to have a fee shifting. And for example, in New Jersey, there can be some fees that are associated with early intervention, but in Pennsylvania, it's free regardless of income. So the process, so we initially there are referrals. So both Part C and Part B have a child find duty. So that means that there's a duty to identify those children who may be eligible for the services. So if you're involved in the program, many programs have relationships with area pediatricians, hospitals, so that they can, and systems in place where the pediatrician can print out a letter to help the family make that initiate that referral process. If you are interested in learning in connecting a child, you can call the statewide connect number, which is here to connect them to early intervention. And that's to initiate the referral. And then there needs to be a reevaluation process. So there's a timeline for that, 60 days under Part B, 45 under Part C. And there's similar yet a little different eligibility process for Part C, where children need to have a developmental delay based on standardized measures or based on the informed clinical opinion of those evaluators who are assessing the child, or they need to be diagnosed with a disability that has either is associated with developmental delay or is associated with likely developmental delay. And that's for Part C. And Part B, there's the process for identifying, based on standardized measures, a developmental delay or a disability. And also, because of that disability or developmental delay, that the child needs specialized instruction or related services. So in Part B, there's the greater eligibility connection to education, adverse education impact, and learning. Although both programs are about providing those developmental services for learning. So after the evaluation, then either there's the development of the individualized education program, the IEP, or for Part C, the IFSP. And then once those are developed, once those plans, those plans that have to be reviewed at least annually, but often more, they have a more periodic review, 6 months. That's when the services, how the child is making progress, should be reviewed. If there are new needs, if there are changed needs, and ideally, the child makes so much progress that maybe they no longer need to receive the speech language services that they were receiving in the past. So that's the service delivery and review is a really important period once that plan is in place. Children can either exit early intervention because they no longer have a developmental delay, or the parents have the ability to withdraw consent for those programs, or they can transition. So there's transition from Part C. There are rules for how you transition for a child who continues to be eligible Part C into Part B. That really is designed under the law to be a seamless transition, so that at the point when the child turns 3, they have a plan in place to start receiving preschool early intervention. And then there's also a transition that occurs when children are 5 or 6, or they're entering kindergarten or first grade, and they're transitioning from the early intervention system. And again, under the state law, there is a transition process that's supposed to be followed for transitioning to school age programs that also really is designed to ensure that there's no gap and that there's a seamless transition and that our families are, participating and engaged in what those services are going to be for their children. And for early intervention, infant and toddler, McKinney-Vento can apply to children who are receiving early intervention services in terms of how those programs are going to be delivered and how the housing status of the family is looked at. They must be one of the things that is required specific for children who are experiencing homelessness is that they be screened. So referred and screened for a developmental delay and then referred for evaluation. And for those children who are experiencing homelessness, they fall under this group that's eligible for at-risk tracking. So if when they're evaluated at birth to 3, if they are not found eligible, then with the consent of the parents, they can continue to be tracked by the county mental health agency in order to determine if maybe they didn't qualify with a developmental delay at 6 months when they were referred and evaluated, but then at 18 months they do. So that tracking can be an important way to ensure that for those populations that are at risk of having a developmental delay. And Rose gave the statistic of more than a quarter of children who are experiencing homelessness also are identified as having a disability. That's a group that we know can correlate that with being eligible for early intervention. And the same is true for children who have an indicated finding of abuse and neglect in the child welfare system, that they also can, if they need to be screened, and based on that screening, then referred for an evaluation. And then if they're not found eligible for early intervention during Part C, they can be they can be included in at-risk tracking. And again, that needs to be something that is agreed to, consented to by the parents, and depending on that can be a question. And I think we do have a slide, and if not, we can talk about it, because I know there have been some questions about how this idea of parent, which is the parent participation and involvement, is really a cornerstone of the IDEA. So of early intervention, school age programming. And for children in the child welfare system, that can be a complicated question about who the parent is. So with at-risk, and so we'll talk about that, but at-risk tracking is something that needs to be consented to by the parents. And that is parent in quotes, because there's a definition within the idea of who that can be if the biological or adoptive parent is not available. So with, I think we've already talked about this in terms of the eligibility process for preschool, is that you have to have, for preschool early intervention, it is that the student needs to qualify with a developmental delay or a disability and need special education and related services because of that. So with evaluations, I mentioned that there's a duty of the agencies that are responsible for early intervention to identify and evaluate those students who are eligible or who are suspected of having a developmental delay or a disability. But caregivers also have the right to request evaluations. And we have the Connect number here and the email there. And just tying this back to what we talked about in terms of preschool push out, we do see the national statistics definitely demonstrate this. And we also see this in Pennsylvania and in our work, that there's a very significant correlation between children who are being pushed out or excluded from early learning settings, preschools, daycares, and disability, so disability related behaviors. So oftentimes, if the child isn't already identified as having a disability or a developmental delay that would qualify for them for early intervention, they probably should have, because the behavior, if the child is being excluded because of their behavior, if the behavior, typically these behaviors are developmentally related and indicate a delay in development that is not that age appropriate peer or their peers are not demonstrating, and if they are being excluded from learning, then that really puts them into that category where likely they would qualify, because if you go back to what I said, you need to have to qualify for preschool early intervention. You need to have that developmental delay or disability and have that adversely impact your education. So many times, children who are being pushed out because of behaviors that relate to some delays that they're experiencing really should be evaluated, and they may not have been identified at that point, but they should be. And so students are, there are, when students are eligible for early intervention, sometimes we see, and we know that this can be correlated with some of the funding advocacy that we are doing, is that there may be gaps in the provision of services for early intervention due to staff turnover or staff unavailability. And there are certainly areas of, for example, speech therapy, where we know that there are provider shortages. There also gaps in terms of service provision. So where children are not getting the early intervention services they need. And then that's another area where we see when they're not receiving their services to address appropriate development of communication skills, for example, they may develop other ways to communicate that are not appropriate, and maybe things like hitting their peers when they get frustrated, that then lead to them being subject to exclusion from their preschool. And again, this is where the early intervention and push out are so directly intertwined. And so it may be oftentimes when we look at what's going on with a child who's being suspended or has been already expelled from a program, we look at and see that there were gaps in services that were provided or services that should have been provided that were not. And it could be that students, because of that, if they were eligible for early intervention and they weren't receiving it, then there could be makeup services or compensatory education that they are due. And so typically what that looks like, it could be services that are provided in kind when, let's say, there was an occupational therapist who was providing services, who then relocated, and the early intervention program wasn't able to staff that position for 3 months, and so the child didn't receive early intervention occupational therapy for 3 months. It could be that the program doubles up the services to provide them in kind, and that could be compensatory education. Or it could be that funds are held for the family to be able to get those services privately, or other services that may address the student's needs. And sometimes we see that students are put onto wait lists. They're told they're on wait lists for services, when really, once you're eligible through an IEP or through an IFSP, then you should be receiving it. There's not really, wait lists aren't really something that are permitted under the law, even though we know that they do occur. And also services where there's interruption in services, or sometimes children weren't evaluated appropriately, needs weren't identified appropriately, and so maybe the plan that was developed, the IEP or the IFSP, wasn't appropriate to begin with. So that may be another basis for compensatory education. Okay, I'm going to turn it back to you, right, Rose?
Yes, thank you, Margie. And I will be discussing some of the legal protections that apply to these students. So, similar to special education in the school age programming, children with disabilities have legal protections. Um, in general, there is no obligation for children to attend preschool, so they do not have to attend preschool if the parent does not want to send them, and there's no law against that. If a child in a family does want to access preschool, though, that's where we get some of these protections that kick in. So, although no child in Pennsylvania should be being suspended and expelled, specifically, children should not be suspended, expelled, or otherwise discriminated against based on housing status, foster care status, immigration status, disability status, including disability-related behaviors and how those might manifest, race, ethnicity, national origin, or skin color. And we will go into, some of these a little bit more in turn. So, like Margie mentioned, something that can come up a lot in special education is understanding who is the parent and who has legal rights in this area. So, under Pennsylvania law, the parent is someone who is legally responsible for the child's care. And this might differ a little bit depending on the situation. But under special education law, the parent can be a biological or adoptive parent. It could be a foster parent or a guardian. It could be an individual acting in the place of a biological or adoptive parent with whom the child lives, or an individual who is legally responsible for the child's welfare. So a way that we might see this often in our office is a grandparent who the child lives with and who takes care of their needs. This could also be a surrogate parent who is appointed by the school district, which is especially likely with an unaccompanied minor, which we'll talk about more. Um, and it could be any of these people, and it also could be an educational decision maker, potentially through CASA or another organization who handles the child's educational decisions. And they would not be the parent, but they would handle education decisions in that matter.
So we had a couple of questions prior, so I just wanted to pop in for a minute about like when or whether a foster parent can consent to an evaluation under early intervention or special education. And as this slide talks about special education law, so that's the IDA and defines who parent is, and that can be a foster parent, but what's important to know is that that first, a biological or adoptive parent is always the preference if they are acting or attempting to act to enforce their rights. So, as attending meetings, communicating with the school, then they would always be the ones, unless their education rights have been taken away. And so, it's important to know what a court order when a child is in dependency in child welfare. Does the court order remove the education rights of the parent? And typically, when that happens, they remove it and they assign it to someone. And so that could be the foster parent. That could be, as Rose said, it could be someone who is with CASA, or it could be someone, a kinship education decision maker. So that's important to understand. But typically, when a child is in child welfare, or not typically, I would say many times parents do retain their education rights. So you need to look to the order about that. But a foster parent could be that person who has the education decision-making authority granted by the court. And then the other question, another question was about sort of the interaction of homelessness and parental providing consent for certain things. And if generally a parent who's experiencing homelessness and their children are living with them retains their education rights. But if we do have, and I'm not sure if this was exactly the question, but we do have situations where a child is unaccompanied, where they've run away. They're no longer living with their parents. They may not even be in the same county. They may be, may not be living with adults. In that situation, that's where the district would need to identify that and assign a surrogate parent who is someone who's trained by the district, who, in order to serve in this role, to advocate for the education rights. So it's only a surrogate parent for purposes of the special education, decision making. Because, as I said, the cornerstone of this law is that parents participate, and that when Congress created it back in the 70s, they thought, well, parents are in the best position to advocate for their children. They're the most self-interested in that. Of course, that's where we see gaps when we have children who have parents who are unable to advocate for a variety of different reasons. So that's where this law has evolved. Okay, thanks, Rose, for letting me jump in there.
Yeah, thank you, Margie. So, with that in mind, we're going to be discussing a couple of the legal protections that would specifically apply to preschoolers who are experiencing homelessness. So, I know that many of you are likely aware of McKinney-Vento and pretty familiar with it, but I'll go through some, pointers and takeaways here and pointing out what would apply to preschool because this can get a little complex as well. But in general, children cannot be excluded from school because of their housing status. And if you aren't aware of it, the McKinney-Vento Act is a federal law that provides protections for students experiencing homelessness. And this is a really broad mandate where the goal is to promote equity and access to education and to remove any barriers that might exist to enrollment, school stability, attendance, or academic success for children and families who are experiencing homelessness. These are protections that apply for as long as the child experiences homelessness, even if that is multiple years or if it is recurring. And as a note, all public school students experiencing homelessness would qualify for protections. And this can get more complex with preschool because of the complex funding scheme of preschool systems and exactly which laws apply where. But these laws do apply to preschool, and they would apply to publicly funded placements such as IU placements, Head Start, or school district programs, though they might not apply the same way to a completely private program. So under McKinney-Vento, a person is considered to be homeless if they lack a fixed, regular, adequate nighttime residence. So that's the legal definition of who would meet this definition. And this could include situations where a child or a youth is unaccompanied or a migrant youth, which I know there have been lots of questions about, living in a shelter, living doubled up with friends or families, living in substandard housing, a car, on the street, or in other places that are not ordinarily used for sleeping. And something that we really try to mention when we're working with parents, especially because there are lots of misconceptions about this, but students who are experiencing homelessness have the same rights to access educational programs. They do not lose any rights because of their housing status, and they have stronger protections to protect school stability and promote equity, like we discussed. Some of the other important takeaways from McKinney-Vento is that schools cannot segregate students, discriminate against them, stigmatize them, deny equal access to, or punish them for their housing status. They cannot require eligible students to prove their address, including by independently verifying or using police to verify that address. Schools should not be counting absences that are caused by housing or disruptions to housing as unexcused or illegal. Fines or fees must be waived for these children. And potentially most importantly, schools and public preschools should be revising any policies that create barriers for students experiencing homelessness and through which they would not be able to access their program. Additionally, schools should designate liaisons to assist and identify eligible students, and liaisons have specific responsibilities to do exactly that, as well as assist with enrollment and participation and refer families to Head Start. So that can be the connection to preschool and potentially EI through this liaison. So they have a really important role to play here. Another right under McKinney-Vento is that students can enroll in a new school where they are now living or where they have a substantial connection under something called immediate enrollment. And what this means is that children should be enrolled immediately on the same day that they seek enrollment, even without the documents that might be normally required for enrollment. So if the school doesn't have the student's IEP, birth certificate, immunizations, or other records that would typically be required if this is a student experiencing homelessness and seeking enrollment in a publicly funded preschool or public school age program. They should be enrolled that day. And then those any issues that might create should be worked out with the liaison on the back end. But the most important thing is ensuring the child's access to school and then obtaining the records. Another protection under McKinney-Vento that also would apply to preschoolers is transportation, as well as school stability and transportation's role in creating school stability. So, LEAs should provide free transportation to and from a student's school of origin. So, a school they attended prior to becoming homelessness or that school close to where they are now. And even if the student becomes permanently housed in the middle of the year, the school should be continuing to provide that transportation until the end of that school year. And this is an area, particularly with preschoolers, that we would, mention that schools should be considering specialized transportation needs. So any transportation plans should be particularly considering the individual student, which means also considering any disabilities or disability related behaviors, as well as their young age. So sometimes we see public transit passes that are given to 4-year-olds with disabilities who would not be able to navigate that system on their own. So this is a place where not any transportation would be okay for any person, just raising the flag. And if you have a student who needs to be transported across district or state lines, but it's in their best interest to continue attending that school of origin, preschool or school age program, then the LEAs from both jurisdictions should be working together to find a way to transport that student. And I will hand it back to Margie.
Right, great. Okay, so before I think we get to questions, we're going to talk about some legal protections for preschoolers in foster care. There are some similarities to McKinney-Vento, but another one is that children cannot be discriminated, be excluded because of their status in foster care. And ESSA is, well, the Every Student Succeeds Act, which that was the reauthorization of the Elementary and Secondary Education Act. But if a child attends a public preschool, then it must meet those requirements under Title I that include school stability. So similar to school stability under McKinney-Vento, this is something that was strengthened in a really a great reflection of policy in the last 10 years when ESSA was enacted. And so a child is entitled to remain in their preschool of origin or their school of origin if they're school age from when they enter into foster care, into the child welfare system, or when there are changes in their residential placement. So they can remain in that school of origin, they can go enroll in the school where their residence is, their new residence is. And transportation also, in order to maintain school stability, preschoolers in public programs can be entitled to transportation. And as Rose was saying with McKinney-Vento Act, this can depend, these rights can depend on what type of preschool program it is. So if there are any questions I mentioned at the outset about Education Law Center, if you have specific questions or you want to refer families to the Education Law Center, we can look more at a specific program to advise whether the rights in terms of school stability would apply. And I'd encourage you or members of your staff to hold on to our number. This I think I already talked about in terms of the protections that apply in terms of school stability. And also I mentioned that when children enter foster care, they you need to look at the order to see whether their biological parents retain their education rights. And courts in Pennsylvania are required to consider education, including preschool, at every proceeding, and make sure that there is an adult who can actively participate in education decision making. So that is an important step that was added to the law there. And just a couple more points. I know we've already talked about early intervention, but from a perspective of preschoolers with disabilities from an anti-discrimination statute. So many early intervention is a program we said for birth to 5. It's administered by county systems under either the mental health offices, behavioral health offices, or the intermediate units. But all programs in Pennsylvania have to adhere to nearly all, not every, but nearly all have to adhere to the Americans with Disabilities Act. Many also have requirements under the Pennsylvania Human Relations Act, the PHRA, and also many have obligations under the IDEA that we talked about. So those, particularly the ADA and the PHRA, really protect against discrimination. So preschools, even private preschools, are required to ensure that they're not discriminating against preschoolers with disabilities. So parents can request reasonable modifications to policies so that their children can have access. They can't be excluded based on their disability. Preschools can't create enrollment criteria that would discriminate based on a child's disability. So there are a lot of different ways that our preschools need to be taking steps to ensure that their policies are inclusive. And that includes ensuring that if there are aids and services that children with disabilities will need to access their programs, that they are allowing them to, or either providing them or allowing them, unless it would be a fundamental alteration of their program or it would be an undue burden for them to provide it. And this slide just talks more about how children with disabilities cannot be excluded from early childhood education on the basis of their disability. And that steps need to take. So children cannot be excluded, children with disabilities cannot be excluded from a program unless their presence poses a direct threat to the health or safety of others. So direct health threat is a high bar, so substantial risk of serious harm. And it has to be an individualized determination. It can't just be saying, well, we never allow children with autism in our program because they have problems with elopement. Well, you can't do that. It needs to be individualized based on that child and the needs of that child. So I think we're about at time, and I think we're going to be moving to questions. But just so that we've mentioned a couple times that we have a helpline. This is our helpline number for Eastern and Central PA. But it's also, if there are folks who are, basically we divide the state at a line going down through State College. So if you're west, we can also connect. We have a helpline for folks on the western part of our state as well. And someone will get back to you within 72 hours, 72, I guess we say business hours. So if you call on Friday, the weekend is excluded. And we will, discuss the problem. If it's a family and they can give us the student's name, that's great, but that's not necessary. Things can be kept anonymous. And we can see what we can do to help, whether it's giving information, giving advice, which is the individualized advice to address the concern. That's the most common. But we also may be able to take on a limited amount of cases for representation. But we also have dozens of fact sheets and self-advocacy tools on our website. So I encourage you to take a look at that. And that, I think, Sarah, are we good to take some questions?
Absolutely. If you both are willing to take questions, we'll definitely leave that time open now. first, but before we do that, just thank you. Just you're both such a have so much knowledge, and it was extremely helpful. So, if anyone has questions now, if you want to put them in the chat or unmute yourself, please do.
There's a question about whether we can get the presentation emailed to us or posted in the chat. We could, I don't know that I can post it in the chat, but we're happy to, Sarah, send it to you and you could email it out.
That's perfect, as long as I have your permission to do that and share. Is it okay to share the recording as well?
Definitely, yeah.
Okay, wonderful, thank you. So, yes, we'll do that. Thank you, Mason. Anyone else have questions? Oh, there you go. There's a long one.
Okay, great. Okay, so the first question is, how does the Education Law Center advocate against suspensions and expulsions when a preschool program is considering it or has already suspended or expelled a child? Rose, do you, seeing as that's directly related to you, do you want to take a stab at that?
Yeah, so it's great if we can get a case before a child has actually been suspended and expelled. It's great if we might be able to do something to prevent that. So when we're in that situation, we try to work as collaboratively as possible to first off understand what might be happening here and what might be fueling that desire to exclude the child. So it might be that we find that the child requires services to support behaviors in the classroom, but is not receiving those services. And in that case, we might be able to advocate for those services to start or connect the family with resources that can support the child in the classroom and might solve the problem of whether or not the preschool wants to continue to exclude the child. If the preschool has already excluded the child, if it's suspensions, we can advocate for that practice to stop, explain some of the anti-discrimination laws that go into this, and again, try to secure supports. If the preschool program is committed to expelling the child, there are also options like submitting complaints against the preschool. There are other non-discrimination avenues that can be taken. And again, in that case, we often find that the family doesn't feel safe or supported going back to that school with their preschooler. So that might be where we work to get supports in place and then find another placement for the child. Would you have anything to add to that, Margie?
No, I think that is, there's a lot of the advocacy that we do often depends on what is the basis for the suspension or the expulsion, like why is it happening? Where do we see gaps? But a lot of it is trying to connect the student and the program to more resources, because there are we don't have them directly in this PowerPoint, but I think in some of the resources that Rose just put in the chat, and thanks for doing that, Rose, we have a fact sheet that's about preventing suspension and expulsion in preschools that talks about some of the statewide resources that you can tap into in terms of, for example, like early childhood mental health consultants that are designed specifically for this to support programs in designing plans to address not just the behavior of this student, but oftentimes we find that when children are being suspended or at risk of expulsion from a program, there might be some other structural concerns within the classroom that could be addressed. The early childhood mental health consultants can be great with that, but then also leveraging early intervention to ensure that children are getting, if it is a student with a disability, getting what they need. I mean, Rose, think about it. And Rose has been with us almost a year, but how many cases have we had that are preschool suspension or expulsion that didn't involve the student with a disability? not many. I can't even, yeah. So it's pretty specifically targeted, unfortunately, to that population. But there's another question in here that is for the past 20 years of working for the early intervention program, I've been told that our intermediate unit is the second lowest paid IU across the state based on funds per child. This impacts the amount of services we can provide to children with disabilities. What can the Education Law Center do to improve the services children receive in our two-county area as compared to children in other counties? This is a huge problem, and it's thank you for sharing that, because we know that Part B is a program that is underfunded. And I talked about some of the Part C early intervention statewide advocacy that we're doing, and we are, as that work is starting to, that advocacy has been leading to some increase in funds for Part C. We're hopeful to be able to pivot to look more at the Part B early intervention system, which we know has significant funding gaps. And we've been in communication with Ocdel. I know that hopefully they reached out to your IU. They said that they are starting to do more soliciting information from IUs prior to making their budget recommendation, so that they understand what the costs of programs are. It's very important to be speaking out about what it means when you don't have the funding that's necessary, what that translates into for children and for learning in your county. And so again, like I said, I'm grateful that you're sharing that with us now. Also would be interested once we're doing more of the Part B advocacy that we have been doing. We're advocating for Ocdel to, they just published a rate study for Part C where they looked at how do the rates that we're paying for our Part C providers across the state compare nationally, and and as you may expect, it indicated that there was a gap, a significant gap of $71 million for those rates from 2022. So we're advocating that there also be a Part B rate study. So if you're interested in that work, again, get connected with Thriving PA, that slide that I had before, because that's the body that's going to be sort of pivoting to do more of the work related to Part B as well. So there are other questions here. If a child resides with a family who they consider parents but are not biological, let me see, the biomom never signed up or got him a birth certificate or any other paperwork, can the family he resides with sign for him as a guardian or caregiver? That is an interesting question. And I feel like I would need a little bit more information about whether they are all, so under the IDEA, you don't need to have a court order to be considered a parent. But a child does need to have a birth certificate in order to enter school. So I'm not sure if this child has a birth certificate or not. So that might be a question to contact us with, but the policy behind the definition of parent and the procedures in the IDEA is that we want to ensure that children who are suspected of needing special education are getting it as quickly as possible. That's the idea behind it. And we want to, if there is, complicated, the adults in the child's life have a complicated history, or that shouldn't be the barrier to them getting the services. Now, I know that it can be, but the policy behind it is that there should be a way. And I think if you have a situation like that's described here, that might be something, and it's a child, let's say in early childhood, I would probably reach out to, I mean, you could definitely contact us, but I'd probably reach out to the to OCDEL, the Office of Child Development and Early Learning, or if it's school age, to the Pennsylvania Department of Education, to see what could be done to ensure that the child is getting those services quickly and as rapidly as possible. But under the IDEA, you don't have to be designated by any sort of court order. But if there's a question about who the biological parent is, you may need to get some intervention of the court if there's a disagreement there. And okay, so good question about shortened day. Is it always categorized as a suspension expulsion? There can be teams that come together and decide that that's appropriate for the child. And we've worked with parents where they think that, especially when you're in a younger age, having a shortened program could be something that would be appropriate. And this is also in child age. School age. It could be that a shortened day is determined, based on the child's disability. There's actually currently a case in the Supreme Court where, because of the student's disability, they weren't able to attend school in the morning. They had a shortened day. That isn't always a suspension or expulsion. The complicated piece comes in when the school thinks that the parent is in agreement and the parent does not feel like they had any other choice than to put their child on a shortened day. So it can become, especially if it is behavioral, then it starts that you need to really understand, as opposed to something that's like based on the child's disability and, because of their medication, they need to sleep in the morning or they need to take naps. So that it may be, but it doesn't always have to. It isn't always, and it can be something that's agreed to. And I would always say, like, if it's something that a team is considering, put it into the IEP, put it into the IFSP, give the parent notice through an IEP. It's going to be through a NORAP, a notice of recommended educational placement, that gives the parent their notice of it, so that it's very clear that that's what's decided and the basis for why it's decided. And having the aid. So I think the problem with the aid being required, Rose, do you want to talk to this? I feel like I'm talking a lot. Do you have thoughts about the aid?
Sure. So aids can certainly be helpful with children. And we know that for some children, having an aid is what allows them to access their education. Um, in those situations, we often either have an aid already in an IEP that may or may not be staffed, and we can do some advocacy there, or it might be a child who requires an aid but has not been given one. The complicating factor here is when a child doesn't necessarily need an aid, because sometimes we will see centers that see a child's diagnosis and require an aid based on that generalization and not based on this particular child and what their needs are, and imposing additional enrollment criteria. So requiring children with disabilities to meet different criteria to attend school than other children without disabilities is discrimination. So that's where it gets tricky a little bit. So it's not always an expulsion requiring a child to have an aid to come to school, but if it is not a child who needs that aid, then it would be discrimination. And if they need that aid, that should be something that should be provided as part of their services.
Right. And it could be that under the ADA, the preschool has the obligation to provide that aid. If they've determined, okay, this child needs an aid, the sort of balancing is providing that aid an undue burden for them. But I think preschool programs don't usually do that sort of analysis, and they just say you need an aid. If you don't have an aid, go get the aid. You find the aid. I've even heard families being told you need to pay for the aid yourself, hire someone who could be in that role, and it leads to kids being out of school for weeks, months, while other systems are working on locating it. A lot of times we also know that it's a child where they're eligible for the aid. They have an IEP that says you should have a PCA on a personal care assistant, but that's not being staffed because there's an aid shortage. So again, then the child is out of school. So if you're in that situation, one thing that a preschool could be thinking about is, when are there times, if the child doesn't have an aid, but they think that there are safety concerns, are there certain times when this child needs an aid, and we could do some staffing shifts so that, if there are concerns about elopement at recess, they have that one-on-one support with someone who's like a floating staff, or some other, or during lunchtime they have that one-on-one staff. So that's what we would encourage if you see that problem. And I feel like there's another one. There's a question about a birth certificate, not having a birth certificate. If it is a child who's in child welfare and in foster care, and they don't have the birth certificate, that shouldn't, as Rose said before, that shouldn't prevent them being able to enroll. And then I think through the county, through the state, they can figure out how they're going to issue a birth certificate for that child, but it shouldn't impact enrollment in a program if the child is in child welfare. If it's a private adoption, there may be other considerations there for how they need to access that prior, coming from that other state. But again, like, think about it again, the policy is we want kids to be able to be in school. So reaching out to agencies like the Office of Child Development and Early Learning, if there are questions, if there are enrollment issues, is a good idea. Great. I don't see any other questions in the chat. We do have it's a very short, quick survey. If you can take it with the QR code here, if you can use your phone to do that. We'll also send this out so you can do it later. Just helps us get some feedback and make changes and improvements in the future. So thank you very much.
Wonderful. Thank you, both Rose and Margie. I'll make sure to encourage folks when I send out the slides and the recording to also complete the survey. I did keep track of some of the questions. I just kind of copied and pasted them. So when I email the two of you with the registration information, I'll make sure to include that. Would you be able to post the link for that survey in the chat as well?
Yeah, I'm trying to pull that up. Sorry about that.
That's okay. I did notice a few were joining from their cell phone, so hard to scan and do that.
Yeah,
Okay.
definitely.
I did just one thing, just one topic that often comes up is sort of the difference between the need for whom can sign between let me try that again. For IEPs, right? Especially when it comes to unaccompanied youth for our school age children versus the difference for who can sign for an IEP, for early intervention, because there certainly is a difference. And, of course, we talk about the IDEA parent, but when we have children and youth who are unaccompanied, have no contact or no living bio family member, the question is who can sign who for the evaluation, or who can sign when an IEP is renewed. And I think just a little bit more clarification around that, if you have a moment to discuss, that would be helpful.
So and you said unaccompanied youth, but
Specifically an unaccompanied homeless youth. So
yeah.
Certainly the differentiation between that, because we definitely have unaccompanied youth whose parents may still be in contact, but they're not living with them. They could be working out of the area, out of state. But specifically
Yeah.
unaccompanied homeless youth,
Yeah.
who are living with a host family. The host family does not even under IDEA for school age, they don't have the right to sign that IEP. They,
Right.
we want to make sure that we differentiate, or if you can differentiate, so that there is less confusion surrounding that.
Right. Yeah. So, if you have a student who is an unaccompanied homeless youth, and their biological parent is advocating. So, well, let me take a step back. It's confusing for some people because generally we think of age 18 as being the age of majority, and in a lot of ways it is, but in terms of education and in particular special education, 21. It doesn't occur. All students, even 19 or 20-year-olds need to have a parent. And so this is where it can become confusing if you have an unaccompanied homeless youth who doesn't have a biological parent or someone who's in that position to advocate for them. So the first question would be, even if the biological parent is, or adoptive parent is living out of state or somewhere else, are they willing to advocate are they acting to advocate? So if the school knows of them, knows their contact information, and contacts them, are they participating in virtual meetings? Well, if that's the case, then the case is closed because they do have those education rights. But if they are not, a lot of times kids have run away because they're unsafe situations. The school district may not have the contact information for those people. So then for that parent, then the school district should appoint a surrogate parent who can fulfill that role. And any of in that slide that Rose went through where we had the parent, other than the biological or an adoptive parent, that's sort of the preference in the law is always them if they are acting. So if the school gets in touch with them and they don't come to a meeting, then that doesn't mean you can't go forward. That's not how it is. It is only if they are acting to assert their rights. So if they're not, then that's when the surrogate parent should be appointed. But then any of those other people underneath could be a possibility. So the district could say, oh, this is a host family. The host family is invested in this child's future right now. So that would be an appropriate person to be a surrogate parent for purposes of the IDEA. So it could be someone like that that's a host. We work with a lot of people who, for whatever reason, children are living with them and they're performing all the roles that a parent would, even though not designated under by some sort of court.
Perfect. Thank you.
Yeah, my pleasure. But these are all great questions that are not easily answered in the abstract. So I would say, if something is coming up, either, reaching out to our helpline or giving our contact information out to other people, to families, to the host family, that would be great. I would encourage you to do that.
Well, thank you, ladies, so very
Great.
much again. It doesn't look like there are any further questions. I just, again, one more time, can't say thank you enough. It was excellent information. Looks like we were getting great feedback in the chat. So thank you all for joining us this afternoon. And if you please make sure that you fill out the post-seminar survey for Rose and Margie. And we will see you all soon, virtually or in person again. Thank you.
Great. Thank you so much.
Yeah.
Thank you.
Bye.
Bye-bye.